I'm going to keep my remarks very brief because I know nobody's here to see me. We're here to enjoy the CLE, and I am really looking forward to it as much as a person who is like kind of participating, but also as a person who is observing, because the information that we're going to receive is so important and so pertinent to real life situations. But I would be remiss to not be giving my very genuine and heartfelt thanks to the Missouri Bar for supporting this effort. From the beginning, it has always been the Missouri Bar kind of being in the background, cheerleading us on as the affinity bars come together in St. Louis and do our thing for Black History Month. And when I say the affinity bars, I mean Hispanic Bar, MAABA, SABA, and of course, Mound City Bar Association. We do the CLE as a tribute to the community, but also as a recognition of African-American culture and heritage in the city. So also I want to thank Dean Johnson of SLU Law School, because he has been so generous in offering this space to use for this effort. So as Alice has said, she's been around from the very beginning, even before I really started taking part in this effort, because she has a genuine interest in bringing law to culture and culture to law, and where those two meet and how important it is. So without further ado, I'm going to let Alice take over, but thank you so much for attending. I really appreciate your attendance. And of course, those on virtual, thank you so much for tuning in.
All right, guys. So Alexandra Johnson, Alex Johnson, technically Alejandra Erika Maria Johnson Herrera de Dan. We'll go with Alex Johnson. I want to start off by acknowledging the indigenous who inhabited this land before colonization, and say thank you to all of you for coming. We may have some French friends with us, either online or via Zoom, and a couple of German friends. My dad was actually the first lay Catholic theology teacher at St. Louis University. So back in the day, and I'm supposed to try to screen share, but you know what, there's been enough technical issues. It's a picture of St. Louis University Magazine honoring my mother, who taught here for over 5 decades, not in SLU law. She was a linguist. And so they were by no means perfect, but they lived their lives as best they could according to their ethics. And it is to them that I dedicate my work on this particular project. We are honored at the Hispanic Bar Association to have had the opportunity to elevate our sister organization, Mound City Bar Association, who leads in so many different areas of civil rights and other social issues in a way that deeply impacts and benefits the Latina community. There is no Black issue that does not touch the Brown community. The school to prison pipeline, every social issue you can think of, and in that, Mound City Bar Association and other folks fighting for rights have benefited other communities, and we appreciate you sharing your platform during Black History Month. This idea of a joint coalition does stem from Mound City Bar Association leadership. They were the ones that first proposed our 4 organizations come together for an ethnically based project and coalition work. As we're doing this work, I would say the central question for me lately has been my impact. I have been doing this. It's good to see my student loan payments paying off in this nice building. And right, like, my money's being put to good use. And I remember being a student and being asked to help when they were going through the hiring process for diverse faculty and staff members. And so that's, a while ago. And what has been my impact? What is the impact of the work that we're all doing? And in order to try to effectuate that positive change, when we think of metrics of success, like how could we possibly measure that? we can look at websites and see, okay, well, when I was a law student, there was only one Leland Ware, some of you may remember him, one African-American faculty member. Where are we now? But it's always the question, what are our metrics of success? How do we measure our impact? And in that, it's my pleasure to introduce Pamela Merritt, who is someone who can help guide the way. We don't need to stumble through the process. There are leaders whose passion for equity and justice burns brightly, shining light on the path ahead. And I want to thank Ms. Merritt, Pamela, for being here, your leadership in this area. You're well known. When I ask people who are doing this type of work, who should we have speak? Your name was at the top of the list of several people. And so we are honored to have you here today. As we go through this presentation, through each one of them, we'd like to ask you to focus on the ethics of the situations being described. So the common thread of all of this is that it is humans, us, making these decisions that are leading to either more equity or injustice or less just results. What are the ethics of the people involved doing all of this? Because it's human construction, right? We are not talking about anything but human construction and choices that we're making. So on the note of choice, Ms. Pamela Merritt.
Thank you. Thank you so very much. And it is a pleasure to be here. As a activist and working in a nonprofit, not used to editing myself down to 30 minutes, but I'm going to do my darndest. So it's my pleasure to speak to you today, wearing multiple hats. So I am the Executive Director of Medical Students for Choice, which is a global nonprofit that supports medical students and physicians in training, access abortion and family planning education and training. So we are in over 34 countries. Our most recent country, Latvia, our largest membership is in the United States. Fastest growing membership is in the Global South. Nothing makes the case for legalized access to reproductive health care like countries that don't have it, and the pregnancy outcomes that result from that. So it's my pleasure to talk to you today also as a St. Louisan. I grew up in St. Louis County in Creve Coeur. I ran from the state as soon as I could, like many people in the 80s, and then returned in 2023 or 2003. So my advocacy really was born in the people I met on, within 5 minutes of here, who are trying to balance intersecting oppression and be parents and be healthy and participate and contribute to their community. So my work is very much so dedicated to them and informed by their experience. Talk really quickly about some historic regulations that help frame kind of where we are now. You know, we are in the United States. It is unique among the so-called developed world as a country that has the worst pregnancy outcomes, meaning more people die here than should of pregnancy-related death, and also spends the most on healthcare and hyper-regulation of healthcare of any country, and also is regressing in its laws that regulate reproductive health. So the history of obstetrics and gynecology, reproductive health and sexual health, and modern advancements in reproductive health care can really be mapped out through on a timeline lining up to the history of racial oppression in this country. So, it has been built through, in most cases, legal, illegal, and state-sanctioned experimentation on the bodies of people of color, specifically Black, Latino, and AAPI people, Native and Indigenous people. So we start from the moment of invasion, when we had the so-called discovery of the United States of North America, you had people arrive to an already populated land and immediately view them through the lens of having no human rights. So Native women, Indigenous women, and were subject to hyper-sexualized attacks, sexual oppression, enslavement, particularly in Central and North America, and were legally not deemed a person. So US rape law didn't apply. And they certainly didn't have the right, the human right was not recognized to their body, their children, their health decisions, or any part of their lives. So off of that history, we then saw, the perpetuation of that oppression. Who is viewed legally as entitled to bodily autonomy and who isn't, is the thread that links all of the eras of history in the United States. So you have the enslavement of African people who were taken to this country through the transatlantic slave trade. I am a descendant of that triangle, and many people are. The history of enslavement was viewed through property law. And so the damage to your property, you would get more time, you were subject to more time in jail for beating a slave that you didn't own. You would face no jail time for rape. You would face no jail time for separating families. So again, the law, in order to incentivize the oppression that was fueling the economy, became adjusted to say that Black women, descendants of slaves, did not have bodily autonomy, did not have the right to decide who to have sex with, certainly didn't have the right to the children that they gave birth to as a result of sexual assault. What they did have the right to do, because nobody knew they were doing it, is find holistic ways to regulate their reproductive health care and to terminate pregnancy. So what you see is the balance of oppressive societies and the need to grab onto what control you can, because whether or not you have children is a direct factor to the quality of life. So whether you are healthy, whether you're able to work in the fields, whether you're able to, survive and raise the children you have is based upon whether you are pregnant or not, because of the health and the dire health straits that people faced. So fast forward to the 60s and 70s, you have the Indian Health Service collaborating with physicians to perform forced sterilizations on Native and Indigenous women. This went on, again, legally, into the 1980s. It is estimated that close to 25% of Native and Indigenous women during that time period were subject to sterilizations without consent, and some authors have actually taken that as high as 40%. We have J. Marion Sims, who was the father of modern gynecology, and many of the surgical techniques in the research that we now have
She does.
on obstetrics and gynecology comes from the horrible atrocities that he committed against enslaved Black
exactly
women,
right.
and over 30 surgeries performed that have been documented without anesthesia that give us everything from the modern speculum to how to position the pelvis when you're doing we have Puerto Rican,
Well, good. Because she has three names.
Hello?
Or Quis Arcton is a long second name.
Philip
Would have taken
Hagme
longer
is not
to remember
muted.
that.
Judge
But,
Hegney, can you mute yourself, please?
yes, I should have, that should have stuck with me.
Judge Hegney, can you mute yourself?
All right, let's try to calm ourselves.
There we go. Sorry. Okay, that was just a weird background to what I was talking about. Sorry about that. So we also have the history of the Puerto Rican birth control trials. So the first large scale trials of birth control, hormonal birth control, the pill, were conducted on women in Puerto Rico. Again, many most without informed consent, and in the 1950s. So this is like history. We know people from these eras of time. Forced sterilization has long been a weapon in the United States, be an illegal weapon that has been used whenever populations fluctuate in a way that makes the power structure uncomfortable. During segregation, forced sterilization was used because of concerns over voting populations. Forced sterilization through eugenics was used mostly on Black women. And then second largest population being white women, again, through the eugenics lens, if somebody had a disability, if somebody either an intellectual or physical disability, or somebody was considered to be promiscuous, they could be subject to forced sterilization. And eugenics really dominated a lot of law. It still does. Kind of still have residue in law in the United States. The idea of people who are deserved of parenthood and people who are not deserved of parenthood is directly connected to those laws. So we get into the current regulation. It does nothing to really address the history of oppression. If anything, it doubles down and further regulates. So, you know, for those who believe in a human right of bodily autonomy, the precedent of some of these regulations outside of the box of abortion and birth control is quite frightening. We currently in the United States are dealing with 12 states, I'm sorry, that have a near total ban on abortion, with very limited exceptions. There are 24 states that are likely to further regulate and ban abortion in the coming years. This is all the result of the Dobbs decision, which threw what was a constitutional right to privacy and bodily autonomy to the states. In Alabama, you have a near total ban. In Arkansas, near total ban. Idaho, a near total ban. Kentucky, Louisiana, Mississippi, Missouri, Oklahoma, South Dakota, Tennessee, Texas, and West Virginia. These are states, each and every one of them, that has some of the highest infant and maternal mortality rates, particularly for Black women and infants in the country. And again, these are dismal rates in a country that is doing a horrible job in failing people who experience pregnancy. We also have states where abortion is just unavailable. So North Dakota and Wisconsin have so hyper-regulated abortion that it's simply not legal or financially possible to open an abortion clinic. So it's a right in name only. And then you have states with gestational age bans. This is important because these are not based in science at all. There's no science that says that a fetus can survive at 14, 15 weeks. But we have states like Arizona, Florida, Georgia, Utah with gestational week bans that are pre-viability. They are before you could ever survive. And then we have states that have bans currently blocked in the courts: Indiana, Wyoming, and Ohio. The reality is that when the ban is blocked in the courts, it then becomes a race against time because I'm speaking to the prior, the courts are rather slow and the cost of keeping a clinic and a license is rather steep. And so we anticipate that that we will see more bans, and we are already seeing additional regulations on medication abortion. We have a case that's probably going to, we're going to get a ruling any second now, that is about whether or not there can be whether or not they can just ban access to mifepristol, which is part of the 2-pill regimen for medication abortion. We have legal cases and legislation that seeks to restrict access to birth control, hormonal birth control specifically. And I just want to close with a little bit of data about the real life impact that these regulations have. So again, this is a history of hyper-regulating who can and cannot exercise bodily autonomy. 1960 something, my mother was not able to access birth control because she had to be married in order to do so. And she was engaged, so her friends told her to make sure that you access birth control, but you can just put a wedding ring on and pretend that you're married already and you can get birth control. So this was the workaround. Married women had bodily autonomy when it came to birth control. Single women did not. And so it's all a perpetuation of laws that regulate what healthcare decisions people can make. We're now seeing the spillover when it comes to things like genetic counseling. So if they can say whether or not you have the right to determine whether to carry a child to term, then they can regulate who is being allowed to terminate pregnancies and who isn't. We have many cases of fetal anomalies that are being identified and diagnosed at 15 weeks in states where there's a 15-week ban. There are people who are carrying, fetuses that are dying and have died up to 30 weeks. And there, not only is their health at stake, their mental health is at stake, and they're financially responsible for this journey, and their future fertility is at risk. We have the regulation of ectopic pregnancies, which many Americans are now learning it might not be as common as we would think, but they're also learning the definition of not common, uncommon, which is that somebody you know has probably had an ectopic pregnancy. And now the difference is that what would be a somewhat poignant medical procedure that preserved future fertility is now based on laws, something that is being restricted, in that doctors have to run out a clock with a lawyer in the room, no offense to lawyers, a lawyer in the room trying to determine whether or not this person is close enough to death to keep that doctor from facing criminal penalties, to keep the hospital from facing deregulation and penalties. And as I stand here in Missouri, the real life impact of this could not be more real. We are sitting in a zip code that has some of the worst Black and infant mortality rates in the country. We have so much money and so much talent in the city of St. Louis. We're also within a really short driving distance to Barnes Jewish Hospital, which is one of the most world-renowned teaching hospitals in the world. And yet there are people who are going to go in and have an ectopic pregnancy, or have a fetal anomaly, or have a catastrophic pregnancy event, and they're not going to be able to get access to healthcare, not because the doctors don't know how, but because it's illegal for them to take action, or worse yet, it's vague. It's a system of, as lawyers, talking to a doctor and trying to get, who needs to get yes and no answers, and there's no yes and no. So the impact is being felt by people who are most oppressed, who are facing intersectional oppressions. They don't get to choose which doctor they go to. They can't drive over the bridge and go to St. Luke's or to another hospital because they don't have the money. They can't even really afford the emergency room bill that they're racking up. And so they're subject to the whims of that lawyer and that doctor. We are looking at people who, in my organization, are unsure about their legal right to a medical education. We don't know whether or not people are going to be able to travel out of the state of Missouri to train on abortion and family planning. It's banned in Missouri, but can they do that if they're attending a state medical school? What is the guidance for this new law? Because we are not regressed into 1972. What we're really dealing with is a new uncharted territory where the regulation does not factor in the advancements in science. So as we wait for the regulation for our legislature to study biology and catch up to the fact that we have genetic counseling, the fact that there are so many things that can be treated in utero, the fact that these laws regulate and limit whether or not doctors can do in utero interventions and what risk they face in doing them, because we've now said that anything you do wrong is a homicide. So we have to wait, and in the time in which we wait, as y'all know better than me, they have to see cases, and cases have to then answer these questions. And in my line of work, those cases mean that people will be harmed, that fertility will be denied and destroyed, and that the faces behind the cases may become celebrities against their own will because of the enormity of the questions we're asking. So that's a little bit of the history. I'm sorry to rush through a lot of it, but the history of legal regulation of reproductive rights. And I will close simply with the fact that abortion is the most regulated medical procedure in the state of Missouri. It is also an incredibly safe procedure, safer than pregnancy in many cases. And I would love to be able to say that those numbers are balancing out. I would love pregnancy to be safer. But every minute that is spent arguing, fighting, and trying to revise these regulations is a minute that's spent not regulating pregnancy or releasing regulations of pregnancy and pregnancy-related care. So that area of law remains neglected while we're worried about the regulation of abortion care. So with that, I think I hope I did good on the time. And with that, I will wrap up. And I'm not sure if I'm taking questions now or, okay, at the end. Thank you very much.
Thank you. Sorry, my doctor wants me to wear this. So we will now be transitioning to Ness Sándoval. And let me take a minute or two to introduce you to Professor Sándoval. I first met him on the board of the Hispanic Leaders Group, and he has done a great deal of work in the statistical area, which allows us to make data-based decisions. We all have, especially when there's a lot of emotions that most of us have around one topic or another. Also just plain marketing, knowing, for example, if you're going to reach a certain community that does not have desktops, but they all have cell phones and they're on social media, you know, how to do really good community outreach. That can be a database decision. Locally, in large part due to the work of Professor Sándoval. He's also spoken to, I've been in meetings with Governor Parson and other leaders in the executive branch of Missouri and legislative branch, informing them of all demographics, and that's what he's here to talk to us about today. So with that, you can look up all the bios. We sent those out, and of course, every one of these people is eminently Googleable. So without further ado, Professor Sándoval.
Great. Thank you very much for inviting me this morning. I have a PowerPoint. The presenters of the conference can share it to those who are here if you want a copy of it. I'm going to keep it down to about 10 minutes. So I've been asked to talk about what's happening in the United States around this topic. And so this basically want to talk a little bit about demographic momentum, because this is an important principle in demography, because it has to be related to births and deaths. And so what's happening in the United States is that we have a lot of demographic population chatter. And so there's a lot of people who believe that they can stop demographic trends through policies, and you can have some impact it, but the great principle of demography is that demographic transitions will happen even if people refuse to believe or acknowledge the trends or facts. And so births and deaths are two of the three demographic transitions that we study at the core. The third is migration. So what's happening in the United States, and what I'm going to be focusing on are births and deaths, but there's another thing that's happening as I speak, is that the United States is in the process of changing our racial and ethnic classifications for the census. The categories that were supposed to happen implemented in 2020 were not implemented because of the Trump administration's desire to keep the categories the same. There was a lawsuit this summer to continue with Obama's decision to change the categories. And just a couple of weeks ago, the Biden administration indicated that they are in fact going to change the racial and ethnic classifications of the United States. So we're going through an experiment in terms of what the categories we're going to use to talk about what's happening demographically in the United States. I'm convinced that we're going to see more changes probably in the next 5 to 6 years. The concept of Asian Americans probably going to change. We see it already happening. People are talking about East Asian, Southeast Asian, and so we can talk more about that. A final part before I get started is the role of immigrants. Immigrants play a very important role when we talk about births and deaths. And so let me get to the heart of the story here. Is the United States is going through a tremendous change. So if you just look at births and deaths over the past 20 years, we can see that the United States always had more babies born than people dying. Per hour, we were growing about 210 people per hour. But it was going down since the Great Recession of 2008. That was a huge demographic shock. And we never recovered demographically, we recovered economically, but fertility rates kept going down, and we see an increase also in deaths. But what COVID introduced another demographic shock. And we can see that in 2020 and 21, we went from 102 people, natural growth per hour, down to 26, now we're down to 23 Americans added per hour. So that's a pretty significant change in our fertility and mortality rates in the United States. So what does this mean? It means that we now have 24 states that have more people dying than are being born. We typically had like 6 states that were in that category: West Virginia, Maine, New Hampshire. But what COVID did, it showed the vulnerability of a lot of states that has excessive deaths, and then we saw that on the fertility side start to decline. And so Florida, Pennsylvania, Ohio, Michigan, these are all new states because of COVID, partly because of COVID, now have more people that are dying than are being born. And then the next slide is kind of a sensitive slide, and there's a big debate in my profession that people argue that I should not be presenting it. So I just want to kind of forewarn you that there is actually a pretty important debate about whether or not we should be talking about this next slide. I'm going to share it anyway. And is that more whites are dying than are being born. And a lot of people in my profession believe that this is leading to a lot of conspiracy theories. People are angry about the change in the United States, but this is just a demographic fact. We have this trend is seen in almost about 45 states now. More whites are dying than are being born. And this is not going to go away. And so my view is that you got to talk about it. You can't ignore that this is what's happening. On the flip side, we have states where we have more babies born than people are dying. And we see that on the demographic string, we see that this is Texas, California, New York. And so in these states, it's really being driven by Latino babies being born. And so, for example, in Texas, every hour, there are 6 Latino babies born for every white baby born. That's today, every hour. The Latino population now outnumbers the white population in Texas. So this has significant implications over the next 30 years, where the Latino population will be the largest, statistically largest population in Texas. And so we see every year that the Latino population is adding about 600,000 new babies to the population every year. This is babies over deaths. So that's the natural growth here. So it's the exact opposite of the white population. So what's happening if we look at the 2020-2010 census and the 2010-2020 census, we see that the majority of the US population growth was driven by the Latino population. And this is probably going to happen for the next 20 to 30 years. This is probably about 50% of the growth in the United States is going to come from the Latino population in these states: Arizona, Atlanta, Georgia, California. And so this is not going to go away. Even if people want to wish it away, the Latinos, the majority of the US population growth is just simply come from Latino babies being born, American babies being born. A very small part of this is going to come from immigration. Just a couple points here. We can see this at the state level. If we look at the components of change, 14 of the 20 fastest components of state population growth was from the Latino population. They're driven by Texas, California, Florida. You can see it there, that you do have, like Texas has a large Asian growth, a large growth in the Black population. But you see that the Latino population is really driving the population growth in all these states that we see there. And then again, if we look at the states that have a decline, it's all white, it's all the white population in these states here, driven by California, New York, Illinois, Pennsylvania, Ohio. You don't see any Black, Asian, or Latino populations represented in a decline in the population. So I think when we think about deaths over births, what we're going to see here is the United States is actually, parts of the United States is in a permanent demographic winter. Some of these states will never reverse itself. Missouri is in a demographic winter. It'll be very difficult for Missouri to have more babies born than deaths born, more babies than deaths, simply because Missouri has a very old population. It's got a lot of baby boomers that are going to transition, and there's simply not enough younger people to have the number of babies to offset the deaths that are coming. Oklahoma just ran into a demographic winter, and so a lot of these states are going to experience something that's probably going to be permanent. But then you have states like Arizona, Texas, California that are having a baby boom. And I just throw this fact out there. There'll be more babies born in Houston, Texas than the entire state of Missouri. And there'll be more babies born in Dallas, Texas than Houston, Texas. And so that's what's happening in Texas. And so the question is, where will those babies go when they migrate? Which states will they make their American dream their home? The demographic spring, so we think of like countries in Africa, but we have a demographic spring of Latino population. Texas, Arizona, California, these are all states that have very large number of Latino babies being born. And so these Americans are going to be moving to other states, and they're going to refurbishing the population in the Midwest. We already see this happening in states like Utah and Nevada. And then finally, just a few points to wrap up my 10 minutes, is the United States is becoming more diverse. We still have international migration coming into the United States. It's at a slower rate, but it's still coming in. And then we have to think what these changes in the categories mean in terms of how we understand racial diversity in the United States. And so I will stop there. I'm at my 10 minutes, and I'll stay around for questions.
Hi, everyone. At this point in the presentation, we're going to take a few minutes for audience questions for our two presenters. So if you are on Zoom, We are monitoring the chat so we can share your questions with our speakers. And of course, if you're in the room's mic'd, so you should be able to speak and have it picked up over Zoom. But I also have this microphone I'm happy to bring to you if we have any issues with sound. We have a couple questions in the room. If you want to stand and speak, we should have sound. And Courtney, if you want to monitor for Zoom, if anyone has issues with sound, I'll walk the mic over.
So as, what are your suggestions about people that we work with to kind of assist with some of the highlighted? What are some of the things we can do proactively?
Thank you very much. So the list is like running through my head. I think it's important for people to hear from lawyers about how they view the laws that are being passed and the regulations that are being passed. And I know that this might be one of the first times you've heard an encouragement of like people want to hear from lawyers. But I think particularly from an academic standpoint, people need to understand what laws do and what they might have been intended to do is very different than what they actually do in practice. And, you know, as the executive director of Medical Students for Choice, I'm always assumed, probably rightfully so, to have a bias. But I think that it's important that people understand how lawyers are viewing the regulations and the laws that are being passed, whether they can look at this and see future problems and beyond just the reproductive rights law community, that people who deal in the criminal justice system need to start talking about the intersection of pregnancy, of incarceration, and also you know, the role that some of these regulations play. And then as we see the criminalization rolling out, again, people really need to hear from lawyers, and that means lawyers need to talk amongst yourselves about what this criminalization is starting to look like. There's a lot of speculation, particularly given the fact that the Missouri abortion bans and criminalized laws explicitly say that, you know, they're targeting abortion providers. But again, that is a 1973 framing for a 2023 world where you can access abortion pills online, then safely terminate a pregnancy, but you're subject to the penalty. In that case, we have absolutely nothing telling us who the criminal is. And so all too often when that is left blank, it's filled with somebody from a marginalized community. So I think it's important, outside of just the reproductive, you know, rights world where we battle kind of at 300,000 feet, that when we get closer to the grassroots, that we are having a conversation that doesn't shy away from reproductive rights regulation and law when it's talking about its impact on your day-to-day role in giving advice, guidance, and representation.
We've got a question from the remote crowd.
Actually, following up on that, since we have an audience of approximately 200 legal professionals, do you have any suggestions? Are there any opportunities where we can volunteer, where we can get involved in some of the work that you're doing?
Yes. For the work that I'm doing and that other reproductive health and sexual health rights activists are doing, a lot of it is being supported by partners at the Center for Reproductive Rights or the National Women's Law Center. But what we really need is advice from lawyers in the states in which we're operating. So local lawyers matter more than ever, and obviously, you know, those national groups will partner with a local lawyer. So I think that's one area of volunteering that would be very helpful. I also think There's resources like If, When, How, that has a legal hotline. I know that Pregnancy Justice, which is the former National Advocates for Pregnant Women, also has a legal hotline for people who might be facing incarceration for drug use during pregnancy, or, in If, When, How is specifically about people who are being criminalized for self-managing an abortion outside of a medical setting, so using those pills. To the extent that you can, volunteering to advise folks who are calling in from Missouri would be wonderful and so helpful, or if you're licensed in Illinois, but it's like the regional expertise is really hard to balance.
So I did see a question for Professor Sándoval in the chat. There was a question where I know you mentioned when you were talking about population demographics shifting, the statistics about the white population and transition to increased minority population for different groups. In the chat, we had a question if you could speak to theories suggesting that the restrictions to access to healthcare are in part related to restricting that population growth.
Well, I think it is state by state. So when we look at race, if you look at, take TANF, for example, temporary assistance for needy families, when you no longer made it a federal entitlement, saying that you're going to have one standard for the entire United States, when you leave it up to states, you see that states impose different types of rules based on the assumption of the racial population of that state. And so you see states like Alabama, Arkansas had very harsh and punitive laws in place. And in states like Wyoming and Maine had very, I would say, very progressive laws to allow poor women to access these benefits. So there is something about race. When you leave it to the state level, there is an element of, I would argue, discrimination that happens based on the racial population of the state population that receives those type of benefits. I did see a question in there about the census categories, and I'm not sure if you're able to see my screen, but what's going to happen, I think, in the 2030 census is if you're able to look at the 2020 census, you'll see that there's no Asian category. The category is made up after the census is done. But there is a category for white, Black, and American Indian. And so what's going to change is we're going to go to a system like this, where currently Hispanic is an ethnicity, but it's going to become a race. And then we're going to see Middle Eastern and North African become a racial classification. And then I don't think it's going to be Asian race. I think what's going to happen is there'll be, are you East Asian? Are you South Asian? And so I think that's going to be the breakdown that happens in 2030. But this has huge implications because right now Hispanic is an ethnicity. So in 2030, those who classify themselves as ethnically Hispanic but white are going to have to make a choice. They're going to have to say they're either Hispanic, they're going to have to say they're white, or they're going to have to say they're biracial. And so that's going to be the implication for this when this gets implemented. And this is being driven by the executive branch. The congressional branch has different definitions of race. We can get into this. But I think one of the other important points of this is, well, who is Hispanic and who's Latino? And this is going to raise the question, I think, that's being debated, are Brazilians Hispanic? And if Brazilians are Hispanic, then it means anybody of Portuguese descent is Hispanic, which means that if you're from Portugal, or if you're from a colony of Portugal, then you're going to be classified as Hispanic in the 2013 census. And so I go through this exercise that Ronaldo, if you follow soccer, if Ronaldo moved to the United States in 2030, he would be classified as a Hispanic under these definitions that people are talking about. So we're going to go through an experiment in terms of changing our racial classifications.
Thank you, Professor Sándoval. I have another question from the room.
So I'm curious if you consider the overlap between this demographic winter that's happening, right? I recognize I moved to Missouri from California, so very different political climates. As we see what's already happening politically with reproductive justice, et cetera, have we seen in the past, or do you anticipate seeing the demographic winter that we're experiencing putting more pressure on that sort of limiting of reproductive justice? Or I just feel like when I looked at that graph and saw the dip, especially that happened during the COVID years, that's going to have to catch up with us eventually within the state. And so I'm curious if we've seen that before, or if there's any concern about that in other political pressure.
I need the mic, I think. I'm sorry.
Sorry, were you directing your question to Professor Sándoval because of the demographics you were discussing?
No.
Oh, okay, sorry.
So thank you for that question. And yeah, I definitely think that that one influences the other. And I've been saying since June 24th of last year, I'm like, I have no idea. The history in the United States is typically when a marginalized community that does not hold political or financial power becomes over a larger population than the population that does hold power, is that you don't see there be a loosening, you actually see a tightening of restrictions. So a lot of it is not by happenstance that you see voter ID laws, you see, just speculation about elections that are that have been disproven in the courts, because there's a great fear of what happens when, when this vote happens. And that's not based on speculation, that's historically proven with desegregation, with the fight for voting rights, even going further back to, the initial rulings legally after Plessy versus Ferguson, when you had people who were descended of slaves. If your grandfather was a slave, if your father was a slave, you couldn't vote. So, so I think what we would like to see, if we're optimistic, is that states that are going through a demographic winter will sit there and think, well, how do we attract people, to do the work? How do we make this state more interesting and appealing to the states that are having population booms? Like, how do we get Colorado to move here? But at least in the short term, and by short term, I mean 10 to 15 years, of 20 years, what you see is the hoarding of power through restrictions. When it comes to reproductive justice, I'm terrified. So I'm not trying to persuade, but I'm just saying what I'm worried about is that whenever you see those kind of radical population shifts, and that I'm very glad that that slide was shown, whenever you see those kind of numbers, what you start to see is policies and legal rulings that err towards that eugenics angle, and that you will see, while they're incentivizing birth in a certain population, they are going to start to de-incentivize and or out and out make impossible birth from other populations. You simply can't adjust for those numbers, as the professor said, based on immigration, even though that's might have a political benefit in framing. The reality is that the majority of those births are American babies. So the issue then becomes something you have to try to control for inside our borders.
Thank you. So my question was about organizations like Planned Parenthood and NARAL, and I'm sure you know all of the names. What are those organizations able to do now, and how do organizations like Miles City Bar Association, Hispanic Bar, MAABA, SABA, how do we partner to, support this effort, to create reproductive equality? Because, we need guidance, as lawyers, you know, of small organizations like MAABA and SABA and stuff, we don't have like a clear perspective sometimes because we do other things. But that doesn't mean we don't want to contribute. So we need for them to tell us, hey, this is what we need from you. And I know my organization, and I don't think I'm doing too much to speak for my affinity bar organizations, would support and show up in force to do what we need to do. I don't know why this microphone is going in and out, so I'm gonna hand it back over. But I would like to hear from you about that.
Thank you for that. And, you know, as somebody who doesn't do any other things, like I live, eat, sleep, breathe this, I get it though. And I'm often reminded that, you know, we need to be more open. So speaking for myself, not necessarily for my colleagues at Planned Parenthood or Pro-Choice Missouri, I would say that, you know, they have their legal area covered. And so the issue is everyday people. And I think we need to do a better job of talking to public defenders, of talking to social workers about how to flag vulnerable people who are being singled out for application of enforcement of these laws. You know, there's that long history that we are all too familiar of in this region of laws for thee but not for me. And unfortunately, when somebody presents at St. John's Mercy off of Ballas Road, they're not going to be subject to the same oversight or legal analysis as somebody who presents at Barnes or a hospital that serves more marginalized communities. So in that sense, it's tricky because that needs to be local. And I can't stress enough that a lot of the advice we're seeing that is being created is from national organizations that might not necessarily be familiar with the inner workings of St. Louis and St. Louis County law and law enforcement. So I think I can say as an advocate who lives in the region, my organization's global, but I am a Missourian who is living in Illinois for all the reasons. Seriously, it took a lot. I've been a reproductive justice activist for 20 years. It took the Dobbs ruling for me to move to the Metro East. But since I don't have to worry about people knocking down my door, I think I'm very mindful that there are folks who do. So I think there are organizations like the Missouri Abortion Fund that it would be great if I could connect you and other bar associations with them, because they might hear stories of people who are being subject to, you know, prosecutorial discretion. I think it's important that, you know, all of the social agencies that work within the community have that relationship. And if there's, like, we're looking at 10 to 15 years if we're lucky. And if we look at what happened in Ireland, we see that it's a 20-year slog. As y'all know, it's much easier to fight to defend laws than to unravel a series of laws after they've been passed. And we are now looking at a network of 24 states, 24 different legal interpretations of abortion rights, bodily autonomy, medical liability, licensure, what you're subject to as a lawyer or as a doctor or as a patient. So when it comes to Missouri, it's really ground zero for the fight for reproductive health, rights, and justice. A lot of the policy and laws and regulations that we now see floating all over the country were first done in a test kitchen in Jefferson City. So this is an opportunity for an ambitious lawyer to really see all that is going to be done as far as attempts at incarcerating people or taking licensure or shutting down hospitals, Missouri is most likely to see that happen. Every day I get phone calls from reporters who are curious as to whether it has. So I think I'm happy to make those connections to the extent that I can. And I also would encourage you to be persistent. You know, folks are super, super busy. So, you know, hitting us up several times is a good idea, but we do need to make those connections sooner rather than later.
At this point, we're going to take a short break before our 10 o'clock program begins, before our second session. If anyone needs a bio break, wants to get something to drink. Thank you so much to our speakers today and our audience for these great questions. I saw in the chat, Denise Lieberman has some connections for volunteer opportunities. I'm Jessica Mendez. I'm with Hispanic Bar. I probably should have introduced myself earlier, but if you email me, I'm happy to share that information out through the organizations involved in coordinating this program and with attendees. And we do have another question in the chat for Professor Sándoval. Unfortunately, we're short on time, but if you email me, I'll try to connect you so you can get an answer to your question. Thank you. We'll be back in just a few minutes.
So we're starting our second session now, health access issues for the traditionally marginalized. I don't know about you, but I found the first session fascinating and the connections that were being drawn by both of the speakers. We will make sure to try to capture those questions from the chat. Thank you to our online participants as well. We are going to be starting now with a session on equity and health access, and specifically with an Asian focus, moving into an Asian focus with great representatives, Alice Wang and Bonyen Lee-Gilmore from the Center for Reproductive Freedom and Planned Parenthood. Erica Williams will hopefully be here to kick us off. It's a little bit hard. She was going to be in person. I do see her for a red circle. I'd like to introduce Erica specifically and bring her to your attention. The work of a red circle, I had the full disclosure, I had the joy of being on her board when she first founded a red circle, a local organization. When you talk about not perpetuating dynamics, problematic dynamics, and one of the things that happens in the nonprofit industry, of course, is if we have organizations that are led by people outside of the community that they are serving and receiving donations and funding and structural institutional support, when folks from within a certain community are actually struggling to get those grants, to get that support. And Erica Williams is from the community, doing her work, and this is kind of a very much of a it's on the ground situation where we have what Pamela Merritt was talking about, that 3,000 feet above view, and then the people that are actually in the trenches dealing with the decisions. And we'll also hear from people in the trenches in our next session. So without further ado, I would encourage you to look up a red circle so it looks like we have a version of Zoom that is not, at least here on this computer, not allowing us to permanently mute others. So again, please keep yourself muted if you are online. And Erica, I'm going to unmute you now. Erica, it looks like I have to ask you to unmute yourself.
Testing 1, 2, 3.
Yes, wonderful. We can hear you. Thank you so much, Erica Williams.
Thank you
The
so
one
much.
and only legendary.
Thank you so much for that great introduction and kind of framing for the work of a Red Circle and other leaders who are Black and Indigenous and other persons of color. That is very true as far as like getting the resources and the attention paid to groups and organizations like ours that are within North St. Louis County and other regions that have been disinvested over the years and have found themselves trying to work on like one issue, like food, for example, but because of the social determinants of health, things like economic stability, access to education, healthcare, and quality clinics and things of that nature, based within a region, within a neighborhood, within a community, health access becomes a real challenge for people and a real challenge for those of us who are trying to work on that issue, because the issues are not one-offs, they're very intersectional. And so, and I will ask that you give me grace this morning because I'm getting over bronchitis. So there's some stuff still going on here. But I am Erica Williams, founder and executive director of A Red Circle. And we started A Red Circle in 2017 to address racial disparities within North St. Louis County. And we landed on kind of honing in on healthy food access. But what that did was that kind of opened the door for us to learn about so many other points of non-access that people face when they're trying to get healthy, become healthier, be well, meet health goals, overcome health challenges. Things like, not being able to get to the clinic because of transportation issues, or not having childcare, or not having the $25 copay that you have to pay when you go to the doctor's office. Those are very real issues within healthcare. One of the first things that we did at A Red Circle was we began to look at the prevalence of moms and babies, Black moms and babies who were dying, one, at higher rates in childcare than white moms. And it wasn't even an income issue. It was straight race, Black versus white versus other races. Black moms in this country are still dying 3 times at higher rates than white moms when they're giving birth. And so one of the things that we did was, after we learned that shocking fact, we began to talk to other people who were actually working in the space of infant and maternal mortality. And one of the most painful things that we learned about the issue is the misnomer, the misguided medical teaching that actually still happens today that talks about a Black woman's body and how a Black woman's body is stronger than bodies of other races and therefore not as likely to experience pain. And so moms asking for support, asking for help, pain medicine, things of that nature, we're not getting it because the doctors were literally thinking that they didn't need it, that they could just be fine without it. And that goes into like a whole nother discussion about health access. One of the other pieces that we began to look at in this space is the absence of healthy food, like really being able to get to healthy food. We all know that nutrition is the foundation of wellness, nutrients and vitamins and all of that, that's old news. But when you live in a region that has a lot more processed foods, highly processed foods, junk foods and things of that nature, when you're trying to fight off things like COVID, for example, and other illnesses, if your body doesn't have the right elements within it, if your blood cells don't have the right levels of iron, it's really hard to do that. So that also impacts health and the ability to get what you need to be healthy. Something else that falls into this social determinants of health is something called built environment. And what that means is those are the things that are surrounding where someone lives. Is there a lot of pollution? Is there a high level of contaminants? Is the air safe? Is there food in the region? Is it somewhere where people can be well mentally? Are there colors and is it safe? Are there sidewalks where people can walk and actually get some exercise and be safe? Or are they concerned about things like traffic accidents, the accident that occurred with the young lady is in the news. You couldn't have missed it. It's in national news now. And she was just walking, but those are the things that are around built environment. Yes, the person was speeding, but there could have been other factors within either that accident or in other neighborhoods. Not good lighting, not good lines on the street, crumbled sidewalks, those types of things. And so when you look at the built environment of where someone lives, all of that impacts health. It's not just about being able to get to the doctor, but being able to take steps beforehand to keep yourself and your family healthy. And those are the types of things that we kind of work on at a Red Circle. Like I said, our main work is focused on increasing healthy food access, but because of the intersectionality of all of these different issues, we find ourselves working with other groups like TrailNet. They're a group that's working with transportation safety issues, making sure that people can cross the street safely, that the buses are running safely and able to stop. We learned of another car accident that happened a couple of weeks ago. There's a bus stop on Lucas and Hunt across the street from some apartments. And at that section of Lucas and Hunt in North County in the Jennings area, there's no lighting. I mean, it's really, really dark. So there's no lighting. The apartments are on one side of the street and on the other side are trees. And so we're, working with TrailNet to see what we can do to address those issues. Now, we do work, back to my example with the moms, we work with other groups that have like moms groups. Jamab Birth Village is an example of that, St. Louis Doula Project. We work with them, one, to help the moms get access to healthy food and to learn about cooking with fresh produce. Because when you're working in a region that doesn't have a lot of fresh produce available, over time, the knowledge and cooking and things of that nature really goes away. And so we work with moms to address those issues. Another social determinant of health is social and community context. And what that means is, are people able to get in space with one another? Now, we know during the pandemic that was an issue, but in normal times, is there somewhere for people to gather? Is there a safe park for kids to play in? If there is there a place for the seniors to get to, because they can't often go too far to find space with people. And so at our gardens, we have garden sites. We have a smaller community garden in the village of Riverview, and we have an urban farm in the city of Pine Lawn. And those are spaces that not only do we grow food and provide, the produce part of it, but they're spaces where people can actually be connected so they can become healthy with one another and share recipes and cooking tips and make it fun and really find support that's needed. And so when you're thinking about health, you have to think about it in a much broader context. One of our pilot programs that we're hoping to launch either later this year or next year is what we're calling the Community Health Network. So we are working to, like I said, get the food out into neighborhoods, into households. But we know that healthy food is not the only thing that keeps people from being healthy, from not being healthy, rather. People have issues, like I said, like transportation, childcare issues, and things of that nature. And so we're hoping that we can pair the people that we are giving the healthy food to with groups that people who are called community health workers. These are people who are kind of like the liaisons between the people and the doctors, because sometimes people are intimidated by doctors, by nurses, by medical personnel. And so we're really hoping that we can find people in the community who are certified community health workers to help bridge that gap, because we know that health and wellness is the foundation for good living. You can't work, you can't shop, you can't serve your community, and you can't even go vote if you're not healthy, because there are so many other barriers that come into that. So that is the work that we do at a Red Circle, and I am so grateful for the opportunity to be able to share with you all.
And the connection between all of those. So we're gonna thank Erica and move on to Bonyen. I think is it Bonyen? Is it you first, or is it Alice was gonna go first? If you could please unmute yourself. I'm asking Alice.
Yeah, I'm happy to go first. Thank you so much for having me here today, and I'm especially humbled to present after the inimitable Pamela Merritt, who I have the privilege of representing in Medical Student for Choice's state constitutional challenge to Georgia's ban on abortion at approximately 6 weeks of pregnancy. So I'll do my best to pick up on some of the threads that Pamela unspooled in her presentation. And I'll start with just a brief introduction of the center's work. So the Center for Reproductive Rights is a global human rights organization that uses the power of the law to protect and expand access to reproductive health care worldwide. I'm a staff attorney on our US litigation team, and what we do is primarily litigate reproductive rights cases across the country. So the bulk of our work entails representing independent abortion clinics in constitutional challenges to state level abortion restrictions. And for those of you who haven't heard of them before, independent clinics are community-based reproductive health clinics. And although they make up a minority of abortion facilities in the United States, they provide the majority of abortions. So they're absolutely critical to abortion access in this country. In addition to the center's abortion programming, we also work on other reproductive rights issues, including access to contraception and protecting maternal health. So I'll move on to do a little bit of level setting for our discussion of how the law limits access to reproductive health care for the most marginalized by providing a brief overview of the difference between reproductive health, reproductive rights, and reproductive justice. So the reproductive health prong of the movement is focused on providing reproductive health care to individuals through direct service delivery. The independent clinics that I just described fulfill this function, as do Planned Parenthoods and other facilities that provide comprehensive sexual and reproductive health services. And it also includes community-based healthcare providers such as midwives and doulas. The reproductive rights prong of the movement primarily focuses on protecting and expanding access to reproductive rights using the tools of litigation and policy advocacy. So the center is an example of a reproductive rights organization, as is National Women's Law Center, which Pamela had referenced. Historically, reproductive rights advocacy has focused on the negative right to terminate a pregnancy. So what I mean by that is it's about limiting the state's ability to encroach on personal autonomy and bodily integrity. These days, reproductive rights advocates are trying to do a better job about advancing a more expansive vision of reproductive autonomy that goes beyond the so-called right to choose. And that brings me to reproductive justice. The reproductive justice framework is grounded in human rights. It encompasses the right to have children, the right to not have children, and the right to parent the children one has in a safe and sustainable community. The reproductive justice framework was developed by women of color in 1994 in response to the mainstream reproductive rights movement's narrow focus on keeping abortion legal. In the view of reproductive justice activists, Roe was never enough to guarantee access to abortion, especially for the most marginalized communities. As Pamela had explained, it was a right in name only for the most oppressed. Reproductive justice was also developed in response to the mainstream reproductive rights movement's insufficient attention to other pressing problems faced by marginalized communities. Pamela alluded to some of these as well, and examples include maternal mortality and morbidity, and sterilization abuse, and other forms of reproductive coercion. The modes of advocacy that reproductive justice advocates rely on include grassroots organizing, storytelling, and providing practical support. So although the three prongs of the reproductive health, rights, and justice movements focus on different priorities and use different strategies, they are, so to speak, three legs of the stool. They're interdependent and each is indispensable. So as reproductive justice advocates have long recognized, Roe was the floor for marginalized communities. As all of you are probably aware, it established constitutional protection for the right to pre-viability abortion in 1973. And the Roe court grounded its holding in the fundamental right to privacy under the 14th Amendment's Due Process Clause. Under the Roe's trimester framework, states could not regulate abortion until after the end of the first trimester, and states couldn't prohibit abortion until after fetal viability. Just 3 years after Roe, Congress passed the Hyde Amendment, which prohibits the use of federal Medicaid funding for abortion care, with very limited exceptions. And in 1980, the Supreme Court upheld the Hyde Amendment in a case called Harris versus McRae, reasoning that the federal constitution doesn't impose any obligation for the government to provide the financial resources for poor people to avail themselves of their constitutional rights. As a result, the Hyde Amendment restricted access to abortion for the most marginalized, even when Roe was still on the books. At the same time, anti-abortion states further chipped away at access by passing laws designed to push abortion out of reach by targeting abortion providers for onerous, medically unnecessary regulations and forcing people seeking abortion to surmount ever higher barriers. So the former are commonly referred to as trap laws, and those include examples such as physical plant requirements for abortion facilities, laws that limit the provision of abortion care to physicians only when it can be safely provided by advanced practice clinicians, and laws that require physicians to have admitting privileges at local hospitals. Examples of laws that erect barriers to patients seeking abortion include mandatory waiting periods that sometimes require more than one trip to the clinic, mandatory biased counseling requirements, restrictions on state Medicaid funding for abortion coverage, and parental notification or consent laws for minors seeking abortion. Like the Hyde Amendment, these restrictions prevent the most marginalized people from accessing abortion, and their impacts fall hardest on people with limited means, Black, Indigenous people of color, undocumented people, young people, and disabled people. And then even those who manage to surmount all of these barriers to access abortion still experience myriad harms, including delays in getting time-sensitive abortion care, increased risk of detection by an abusive partner or family member, being pushed further into poverty due to missed work or having to reallocate resources from other bills, and stigma. These restrictions also interfere with the physician-patient relationship and undermine medical ethics. So the principles for medical ethics are respecting patient autonomy, beneficence, non-maleficence, and justice. And abortion restrictions violate all of these principles. They interfere with patients' autonomy over their healthcare decisions. They prevent healthcare professionals from acting in accordance with their patients' best interests, and they exacerbate existing inequity. So Roe was never enough, but despite its shortcomings, it was a critical backstop for preserving legal abortion, and it was integral to the whole line of jurisprudence that protects our ability to make deeply personal decisions about our bodies and our families. As all of you know, the Supreme Court overturned Roe and Dobbs last summer, rescinding constitutional protection for the right to abortion. And as anticipated, Dobbs has resulted in unquantifiable harm across the country, especially for marginalized communities. States moved swiftly to ban abortion by executing so-called trigger bans, which are laws that were designed to spring into effect if and when Roe was overturned. And they also enforced or tried to enforce pre-Roe criminal bans that had remained on the books. Now that state legislatures are back in session, anti-abortion states are passing still new abortion bans. So I believe the most current count is that 11 states currently have total bans on abortion. And in fact, this shifts on a day-to-day basis because of ongoing litigation. And several others have draconian gestational bans as early as 6 weeks of pregnancy. As a result, large swaths of the South and Midwest are now abortion deserts. That means that those who have the resources are forced to travel hundreds, if not thousands of miles, and surmount the costs and barriers of missed work, childcare, and lodging to obtain abortion care in haven states. But approximately half of people who need abortion live in poverty. So those who aren't able to raise the necessary funds and overcome all of those logistical challenges are left with the options of attempting to terminate their pregnancy outside the formal medical system, or being forced to carry their pregnancy to term and give birth against their will. Now, going back to medical ethics, hospital doctors in ban states are hand-tied when presented with pregnant people who are experiencing miscarriage or other medical crises. And this includes people with wanted pregnancies. So even when bans have medical emergency exceptions, those exceptions tend to be drafted in such a narrow and vague way that when combined with the ban's draconian criminal penalties, chill doctors' ability to offer medically appropriate care. And withholding medically necessary health care until a patient gets sick enough contravenes the principle of beneficence. People shouldn't have to wait for their health to deteriorate before doctors can intervene without fear of prosecution. In addition to all of these devastating on-the-ground impacts, Dobbs also engendered a cataclysmic shift to constitutional law. The bottom line is that it constrains both the scope and the meaning of liberty to a time when marginalized people, including women and people of color, were not considered full and equal citizens. So to go over its constitutional analysis, the court departed from the premise that unless a right is specifically enumerated in the Constitution, it's only protected under the 14th Amendment if it's deeply rooted in the nation's history. And the court adopted a really narrow analysis to determine what is deeply rooted, looking only whether the right was affirmatively protected by a majority of states at the time that the 14th Amendment was ratified in 1868. So that, of course, ignores the fact that people capable of becoming pregnant didn't have any voice in the political process at that time. And under the court's reasoning, there's nothing stopping it from stripping away other rights that this nation has historically denied marginalized groups, such as the right to marry someone of the same sex. So this constitutional vision essentially hurdles us back in time, and it's deeply troubling for communities who were historically oppressed. I know that all of that was really bleak, so to end on a forward-looking note, I think the silver lining of suffering the worst case scenario in our movement is that it clears the way to imagine and fight for a bolder and more expansive vision of reproductive autonomy that centers those who were previously left behind. So make no mistake that restoring access to legal abortion and rebuilding the jurisprudence is going to take a long, long time, and the process is going to be very incremental. But it is critical that no matter how much of an uphill battle we face, the movement not give ground to a more expansive conception of reproductive autonomy than Roe's previous high water mark.
Thank you so much. So Alice brought up that really critical point, right, of medical personnel. Oftentimes when we think about criminalizing folks, we think of women making the decisions, perhaps the people immediately helping the woman make the decision, driving her through to another state or something, crossing federal lines, we think of those, but the medical personnel, right, and the ethics that they're facing, as she mentioned, even in wanted pregnancy scenarios, and being handbound. Tying into the, if you're going to support the pregnancy and a healthy environment that Erica was talking about, we'll now shift to Bonyen Lee. One of the things that concerned, I think, several of us organizers as we were working through this was the lack of information with regarding to the AAPI community and Asian communities in general. And Bonyen will talk to us about that. Bonyen, you are still muted. So if you could go ahead, I'm going to ask you to unmute. Looking on that.
Hi, can you hear me?
Yes.
Okay, great. Hi, everyone. And I want to first thank Alice and Erica and Pamela, who are all allies in this work. And I want to thank everyone here for joining me in community today. My name is Bonyen Lee-Gilmore. I use she, her pronouns. I am the Vice President of Strategy and Communications at Planned Parenthood of the St. Louis region and Southwest Missouri. And I'll share more in a little bit about the work we do there and how that intersects with a justice lens, an approach to ensuring equitable access to reproductive health care. To piggyback off of Alice's talk about the difference between reproductive justice and reproductive rights, Planned Parenthood is a reproductive rights and healthcare providing organization. And we recognize that we cannot achieve our rights or achieve rights or access without ensuring that we are doing it with an equity lens and centering those who are most impacted by policies. So I will touch on that more in just a bit, but first I want to offer a happy Black History and Futures Month to everyone. I'm hoping today that I can share with you perspectives on the interconnectedness of social justice issues, including racial justice, reproductive freedom, and the fight for liberation, and that you will sharpen your understanding of how these movements share a through line, and that we cannot achieve freedom until we are all equal. And in this vein, I want to recognize this group for recognizing the importance of the common thread, as Alexandra said earlier, all of our shared identities across the social justice issues. But first, bar associations I want to share are a special group to me, especially the Asian American Bar Association. My father was the first Asian attorney in the state of Missouri to receive his bar license, and for many years was the only immigration attorney to practice in the state. And as a daughter of Chinese immigrants and a first-gen American, I see us as trailblazers of our own in the many small and big aspects of life. I'm sure I'm not the only one who remembers the trauma of school lunchtime when it was time to take out our homemade bowl of rice and insert exotic side dish for the Asian attorneys and judges in the room today. My father shared stories of how judges in this state always asked him to approach the bench to show his bar card before being able to proceed in court. These many microaggressions we've collectively endured has led to cultural change where more of our stories are being told and our experiences normalized, and of course, our identities honored. Yet systems of oppression continue to erase us, harm us, and threaten our futures, and it is how we respond as a community and how we disrupt cultural norms that will matter for generations of people of color after us. When I was approached and asked to talk about the impact of abortion bans on the Asian community, I had to pause because, to be honest, this isn't really a frequent topic of interest in and around the communities where I work and live in Kansas City, Missouri. And even across the reproductive rights movement, the impact to Asian communities, AAPI communities, our activism, our visibility are often othered and deprioritized. Layer in a landscape like Missouri, where most of us work in white dominant spaces where abortion is already stigmatized, pressure to assimilate and unconscious model minority tendencies take over. I've been there and continue to reckon with these realities myself in the boardroom, in social spaces, and in movement spaces. Today, I work at the intersections of reproductive health rights and justice. I specialize in strategy and communications at, like I said, Planned Parenthood of the St. Louis region in Southwest Missouri. My organization was the last remaining abortion provider in Missouri until 7 minutes after the Supreme Court decision in Dobbs v. Jackson was released on June 24th of last year. And that day, nearly 50 years of federal rights to abortion ended. But abortion wasn't banned overnight. So I want to share some reflections on how we got here before I talk a bit about what the impact of Dobbs v. Jackson has had on communities of color, including the Asian diaspora. It's important to acknowledge that anti-abortion politicians have systematically dismantled reproductive freedom first on the backs of Asian, Black, Hispanic, Latino, and Indigenous people over decades. Mostly white and male politicians spent years passing racist and discriminatory laws that created a system where control over one's reproductive health, including whether and when to start a family, was for the privileged. If you had money and means to take time off work and travel long distances to the one provider in your state, then abortion was accessible to you. If you lived in the 1% of counties with an abortion provider, because remember, before Roe was overturned, 99% of counties in the United States had no abortion provider at all, then abortion was accessible to you. But the reality is, racist and discriminatory systems have long forced women, people of color, immigrants, and young people to go without. Private and public insurance bans, mandatory waiting periods, 2-trip requirements, and a maze of abortion licensing schemes designed to shutter clinic doors created a Missouri where abortion was all but banned, especially for marginalized communities. In the year before Roe was overturned, the last remaining abortion provider cared for 50 patients. And that's down from 167 patients the year before and thousands of patients a year 5 to 10 years before that. My point is access eroded long before Roe fell. Anti-abortion operatives didn't chip away at abortion access in a silo. They created stigmatizing narratives that perpetuated offensive stereotypes against marginalized communities, including Asian American and Pacific Islander people and those with disabilities, in an effort to fearmonger, shame, and stigmatize abortion providers and their patients. For example, anti-abortion politicians pushed reason bans, preventing patients from making pregnancy decisions about their fetal diagnoses, demonizing these personal decisions by wedging the disabled community against pro-abortion advocates. The same anti-abortion politicians introduced sex-selective bans and repeated debunked racist tropes about Chinese and Indian families. The National Asian Pacific American Women's Forum has called these bans a wolf in sheep's clothing. Since 2009, nearly half of all states have considered sex-selective abortion bans, and the federal government. The impact of these bans created a political barrier in the exam room, arbitrarily dismantling the patient-provider relationship built on open communication and trust. This was one of the early manifestations of provider and patient paranoia, panic that any conversation could be misinterpreted and weaponized against them. Using Asian people as a wedge to create false narratives around good and bad minorities is part of this country's shameful history. The model minority myth has both benefited us while keeping us quiet and submissive to dominant cultural norms. Respectability politics, defined as a set of beliefs that mainstream standards of appearance and behavior will protect a person who is part of a marginalized group, enables the silencing and erasure of AAPI communities. This is by design. Our community silence enables those in power to inflict harm, perpetuate racist tropes, and create offensive narratives against us. Layered on top of racist and discriminatory systems used against the AAPI community is the patriarchal cultural norms many of us have experienced or learned about in our ancestral histories. A person's reproductive system used and valued over the person themselves. Those of us in the room who might relate to these layered and complex lived experiences can uniquely understand the multiple identities we navigate within ourselves. I know as a young Chinese American, my Chinese immigrant parents told me, you will walk through this country not recognized as an American and not recognized as Chinese by our own. This is a shared struggle across non-white people of color. We want to dismantle white supremacy against our own. We must acknowledge the interconnectedness between dismantling anti-Asian hate and anti-Blackness. It's important for the AAPI community to recognize the many ways anti-Blackness permeates our culture and the ways in which we've allowed ourselves to be used as a political wedge. I likely don't need to lecture this audience about the role Asian legal groups like the Asian American Legal Foundation has had in working against affirmative action by singularly advocating for Asian Americans at the expense of other people of color. The white dominant culture in this country has long used the model minority myth to manipulate their power to continue cycles of oppression against Black and brown folks. The fight for reproductive freedom has not been immune to this. As is true for all oppressive systems, inaction will only benefit a marginalized group for so long before it becomes their problem too. In recent years, we've seen an uptick in violence rooted in racism against AAPI communities. According to AAPI data and Momentive, in 2021, 1 in 6 Asians reported experiencing a hate crime, up from 1 in 8 in 2020. In 2022, 1 in 5 Americans believe Asian Americans are partly responsible for COVID. We must not allow ourselves to believe that economic freedom or financial success rights the wrongs of systemic oppression. It is incumbent on us to join the fight for social justice because justice and liberation are everyone's fight, not to mention a real part of our shared history. If you want a better understanding of the interconnectedness of oppressive systems, just look at what's happened to our public health system in a post-Roe reality. During the height of anti-abortion policymaking between 2010 and 2020, pro-abortion advocates worked in vain to get healthcare and higher education institutions to join us in fighting back against medically unnecessary restrictions. Did these anti-abortion policies and impact hospitals or colleges at the time? Indirectly, not necessarily in those moments, but guess what? They absolutely do now. In the wake of Dobbs v. Jackson, the same hospitals that refused to testify against anti-abortion policies are now being harassed by anti-abortion protesters. Wash U's Children's Hospital is now under the same kind of sham investigation for their trans care program that abortion providers endured for their abortion care programs for decades. We said all along, they start with abortion, but they won't stop at banning it. They'll use the same tools to attack trans rights, marriage equality, and other rights and freedoms we've fought long and hard for. And these attacks disproportionately impact people of color, immigrants, and young folks. This is what interconnectedness looks like. Today in Missouri, under the state's total ban on abortion, with exceptions for medical emergencies, all doctors, not just abortion providers, face prison time should our Attorney General disagree with a medical decision that involves abortion. Pregnant people are being forced to wait until they are sick enough before doctors can intervene with a life-saving abortion. And the decades of inaction and silence from medical institutions have now caught up to us all. In short, no doctor is immune from the scrutiny created by politicians, and no patient immune from this hell. So now Roe is overturned, abortion is banned in Missouri, what happens? There is great debate across the country among pro-abortion advocates. Do we look for compromise in order to open up some access, or do we push for something better than Roe? I often remind people that settling for a compromise you would have never accepted in the past is exactly what oppressive systems are designed to do. Systemic oppression stops us from daring to believe in a just future. It corners us into this good enough mentality and forces us to leave people behind. I would argue that this mentality has led to the systematic erosion of the judicial system, which is now filled with anti-abortion activist judges. And it will be people of color, immigrants, people with low incomes, and young people who will lose the most. Language barriers, immigration status, and access to insurance were roadblocks even with Roe and continue to make it hard, if not impossible, for AAPI patients to access care after Roe. Reaching for the low-hanging fruit in this moment is an act of oppression, not liberation. We can and we must do better. It's too soon to know the full scope of impact to the AAPI community in the wake of Dobbs, but there is real action that needs to be taken so we can better understand how harmful policies impact us. For one, we need more equitable distribution of funding. Between 1983 and 2018, AAPI organizations only received 0.2% from foundations. For those of you who aren't good at math, because I'm not, that means for every $100 awarded to organizations, only 20 cents were designated for AAPI communities. We need to see disaggregated data. This was kind of touched on earlier. Asian Americans are often lumped in with other racial demographics, making it hard to find data-driven impact information on our communities. Yet Asian Americans are one of the fastest growing groups of eligible voters. This level of erasure makes it challenging for our communities to push for change. What we do know is that 2/3 of Asian Americans and 1/5 of Pacific Islanders are foreign-born. In a post-Roe reality where abortion is criminalized, the AAPI community is experiencing an elevated level of fear when accessing abortion. There is an incredible amount of potential the legal community can do to educate people about the rights and risks. I encourage you to work with reproductive freedom experts to mobilize your working community. We are here to be a thought partner with you. We just ask that you work in lockstep with those of us who are expert practitioners in reproductive health, rights, and justice. But we are always looking to partner with pro bono attorneys, especially on the ground. Take a look at your workplace. It's not enough to have AAPI employee resource groups if your employer doesn't have. Also take a stance on healthcare access, which includes abortion care. Again, attacks on our rights and freedoms disproportionately harm us. So providing spaces without supporting our ability to live free and healthy is performative. Utilize your employee resource groups to ask hard questions about your insurance coverage. Does it include a rider for abortion care? And will your employer cover expenses if you need to travel out of the state for an abortion, because if you live in Missouri, you will have to flee the state for care. This next call to action is specifically for my AAPI friends in the room. Find your voice and join the fight, because representation matters. I must end by sharing a very intentional disclaimer that these calls to action are not political. Abortion is healthcare. It is a basic human right, just like any other healthcare you might find yourself wanting or needing in the future. The politicization of reproductive healthcare is calculated. If political systems can convince you that abortion is a political topic, it keeps abortion out of reach for institutions and organizations that do not engage in political action. Abortion is foundational to our economic freedom and our ability to build the lives we each authentically deserve. And I urge each of you to consider the individual role you each play in normalizing abortion as healthcare and dismantling systems of white supremacy, because our fights are interconnected. Thank you.
You know, when we were researching speakers for this presentation, thank you so much, Bonyen. The threads, you can hear them, right? Like, she's coming at it from her angle. Pamela Merritt is like, hey, look at the history, starting with Indigenous. Then we see Sándoval in his corner of the world looking at demographics, and you hear all the threads. So thank you for all three presenters. We are going to move to some Q&A questions. We have a great question in the chat from Mike. Some cities have medical legal partnerships, but they haven't caught on here. North County and groups like a Red Circle would really benefit from establishing some partnerships. Why have they not caught on here? Any of the speakers, I think, could speak to this or could answer this, but Erica, if you want to unmute yourself and come back on, or not. Okay, well, while we're waiting for that question to be answered, back on, does anybody have a question for the, another question, a different question? Anybody in the audience? All right, well, I don't think, let's see, oops, I have new messages, see if I've missed here. This is
Diarra Williams. She's having trouble on TV.
She's having, let's see, ask to.
Oh, there it goes.
Is it, did it work now? Okay,
Yep.
So why have those partnerships not caught on? And then I will go to the other question that we put in the chat. Those medical legal partnerships, Erica. And Erica talks a lot about funding and how the process of funding itself is biased. And Bonyen just mentioned that 20 cents out of every 100 go to AAPI. So this is a very interesting question, Erica. I know you can speak to it.
All right, thank you, Alex. You mind reading it one more time?
Yes.
I want to make sure I capture it right. I was getting a little off when I was trying to unmute.
Some cities have medical legal partnerships as promoted by GW Med School and others, but they haven't caught on here. North County and groups like a Red Circle could really benefit from them. Why haven't they caught on here, in your opinion? Racism?
Yeah, that's I am.
You think that might
Right.
have a role, Eric? I was on her board, so I know her.
So yeah, we at a Red Circle will work and collaborate with anyone who wants to collaborate and has good intentions, I would say. Sometimes even in like the space of nonprofit field, when there's a medical nonprofit and a nonprofit like ours that's community-based, sometimes those don't fall through very well because the intentions of the groups are very different. For example, we try to partner with a medical nonprofit that kind of focus more on like breast cancer patients to try to get some of their services and resources and information into North County. And there were several factors involved, but that partnership ended up not being able to manifest as we had intended. we meaning both that group and us. There's so many like just different nuances. So we're trying to open a grocery store here in North County that will help to mitigate the food desert that is in a lot of our neighborhoods. And we're working with local farmers to get fresh produce into the community, some jobs and things of that nature. And we've been in talks with a couple of different healthcare systems about doing things like food as medicine projects, so that patients that are dealing with, whether it's pregnancy, diabetes, cancer, if they have a prescription from their doctor to eat more fresh produce, we can be the site not only to sell the fresh produce and get reimbursed through a produce type pharmacy setup, but also we'll have space within the building where the store is going to be to teach classes about cooking and cooking tips and nutrition. We're actually purchasing a building, and we're going to have the building renovated to do this work. And in that space, we'll have some cooking stations so that we can actually show and do cooking demonstrations together. So anyway, I say all that to say, there's so many chains of command that have to go into finalizing and forming and actually implementing a partnership. And right now, we just, here in the state, we just don't have the infrastructure and the wherewithal yet. Everyone is so separated. Everyone wants to do their own thing. So we're trying to overcome that while we still continue to focus on our community.
Wonderful. I don't know if Bonyen or Alice had any answers to that question, but I do know we have another interesting one. They can pick up the new question or add any thoughts if they have something to the previous question. This is not reproductive rights specific, but do the speakers have any thoughts on how the ending of the public health emergency, emergency is likely to impact equity and access to healthcare for marginalized groups, especially those who are at risk, increased risk of bad outcomes for COVID? Is anyone aware of advocacy efforts in this area? So we have a medical legal partnership link there, but do Bonyen or Alice have any thoughts? I don't know if Erica may have some more thoughts. We just talked about this equity and access is being so critical. Speakers? I love hybrid CLEs. Okay, all right. Well, all three of our speakers are muted. Maybe is it that I have to ask them to unmute themselves again? Alice, I've asked you to unmute yourself. I don't know if that helps.
There we go. Okay.
It may be good for the speakers for this portion to not mute yourself again until we kind of complete the portion, if you don't mind. So it looks like we're having problems with the unmuting. Okay. Ending of the public health emergency, impact on equity and access. Alice?
Oh, I don't really have thoughts on this. I'm not an expert on this area, but I would think as to the question of whether there are volunteer opportunities, that disability rights and justice organizations might be a good place to start.
Okay. Don't mute yourself anymore. All right.
I will say that there are always volunteer attorneys to become advocates. You know, being a paralegal for 12 years, I learned that prior to me forming a Red Circle, that attorneys and their staff are very good at finding evidence and doing research and even drafting. And so being advocates for, you know, things like more funding and spaces. And one of the things that we're going to be working, I keep talking about the stuff we're going to be working on, but we're going to look at later on this year some information around food pricing, because we know that one of the barriers to people getting healthy food is that it costs more than cheap food. it costs more than junk food, than processed food. And so when you're looking at health, you have to look at, this whole really well-rounded part of it. Is the food made available to help people get healthy? Can they get to the doctor's office? If the doctor says you should eat more fruits and vegetables, then you go to the store and try to buy them. Can you afford them? And so looking at, things from a policy perspective, an advocacy perspective, is definitely a way that attorneys can volunteer with us.
Bonyen, did you have any other thoughts on that?
Nope.
I have a question, and I just scrolled quickly. Let me see if I can do this, guys, because I have a question from somebody who wishes to remain anonymous. And, but if I pull it up on the screen, then my in-person crowd can see it. So give me 1 second. And for some reason, it's not coming up on my phone because I think it's a second account. So can everybody in person just avert your eyes quickly? Just give me a little bit of privacy. And the person who had this question. Okay, for I prefer that way I don't even have to look at. I would like to ask the panelists why reproductive rights attorneys are not arguing that the anti-abortion laws violate equal protection under the law. Alice, you're the attorney on this session. Do you have any thoughts on this?
I'm not really at liberty to comment on, litigation strategy. I will say that various avenues of constitutional challenge have been explored, and litigators are continuing to explore every potential option. And I will also say that in the past, including leading up to Roe, that there were simultaneously cases that did bring equal protection claims. And it was sort of historical circumstance that Roe was the case that reached the Supreme Court first. And the court decided it on due process grounds. So that was as much a matter of historical accident as anything else.
Interesting. Guys, we are at our time limit. And I just want to let you know that I'm getting texts. This happens to me a lot of times when I'm speaking publicly, because I'm kind of an outspoken person, but I'm getting texts saying things like, this has been amazing, continue this work. And so I know that we've had some technical issues, but I appreciate your patience, and I very much appreciate our 3 panelists for this session. Thank you so much for logging in from all the places that you are. And Bonyen, I think you're going abroad tomorrow, right? So safe travels to all of you. Be well. Thank you. So with that, I'm going to transfer control of the mic to my buddy Rick. We can't take a break if anybody needs a bio break, but we're going to catch up on the time loss by jumping right into the last panel. And we have the wonderful attorneys we've been talking about, boots on the ground, Matt Fry from Rosenblum Schwartz and Fry. Some of us remember back when it was just Rosenblum Schwartz, but now it's Rosenblum Schwartz and Fry. So somebody made partner. Name partner. I'll do that. Come on in, Matt. Hello. Kevin is also a local practitioner.
Hi, guys. I'm Rick Hein. I am privileged to serve as the president of the Hispanic Bar Association. I want to thank all of the speakers thus far, and as well as the Mound City Bar Association for permitting the Hispanic Bar Association to collaborate on this very important CLE in honor of Black History Month. Also would like to thank SLU Law, Dean Johnson, and Julie Orr for helping organize, permitting us the space, also to the Missouri Bar for sponsoring the lunch afterwards, and to the entire planning committee. I'm supposed to be the mediator. but I want to set the table a little bit. The moderator, sorry.
Nobody's fighting.
Sit over there. Just sit down, will you? The Supreme Court case came down in 2010 called Padilla versus Kentucky. Jose Padilla was a fellow from Honduras, served honorably and was discharged from the United States military during the Vietnam War, and was a legal permanent resident of the United States for more than 40 years. He was charged with trafficking in marijuana, possession of marijuana, and possession of drug paraphernalia in Kentucky. Before he pled guilty, Mr. Padilla claimed that he was a criminal, that his criminal defense lawyer had told him not to worry about deportation since he lived in the United States for so long. He also claimed that his lawyer failed to advise him of deportation as a possible consequence of pleading guilty. So imagine Mr. Padilla's surprise when, after he pled guilty, he was placed into deportation proceedings. In post-conviction proceedings, he alleged that he would have gone ahead and gone to trial had he not received the incorrect advice that he didn't need to worry about pleading guilty to these drug offenses. The Padilla court, the United States Supreme Court, said that preserving a client's right to remain in the United States may be more important to the client than any potential jail sentence, especially if deportation is one of the consequences. The Supreme Court said that the duty of a private practitioner in these cases is to do more than just advise a non-citizen that pending criminal charges may carry a risk of adverse immigration consequences, and to give correct advice to the defendant. The Supreme Court held it is our responsibility under the Constitution to ensure that no criminal defendant, whether a citizen or not, is left to the mercies of incompetent counsel. To satisfy this responsibility, we now hold counsel must inform her client whether his plea carries a risk of deportation. Our longstanding Sixth Amendment precedents, the seriousness of deportation as a consequence of a criminal plea, and the concomitant impact of deportation on families living lawfully in this country demand no less. And so now I'm handling a case where a fellow was charged originally with 11 felony counts of failure to file a sales tax return. His lawyer was able to negotiate a plea whereby he would plead guilty to 4 misdemeanor counts of failing to file a sales tax return. And then he was placed into proceedings. So now I'm handling this case in front of a Missouri trial court judge, the plea court. And we filed a motion to set that aside. The state, however, has now argued that the rule, the criminal rule, which is 2907D, is not available to a defendant because my client was placed on probation, received a suspended imposition of sentence, and successfully completed his probation. The state's attorney is citing a case called Cobble versus Hartenbach, which is a Missouri Supreme Court case written in 2007. In fact, the author of this case is sitting in the second row.
Did I screw it up?
So Judge Wolf held that there was Judge Wolf held that there's no relief available under this rule because the defendant received a suspended imposition of sentence. And in the case he had before him, that was a sex offender case whereby a fella had pled guilty to a sex charge, which was then later, the statute was then later held to be unconstitutional, but he was already on the sex registry, sex offender registry. So Judge Wolf said, well, you could go ahead and try to get the sex registry to respond to you to get you off the registry. So you have a remedy. But that leaves the question in my case, what remedy does Missouri offer for a non-citizen to withdraw a plea of guilty under this United States Supreme Court case when the person has already completed their probation successfully. Now, I've argued that in spite of what Judge Wolf said, the plain language of the rule does permit a motion. So if there are other lawyers here who have any other ideas, I'd be open to suggestions. In the meantime, let me introduce the speakers. So Matt Fry is a criminal defense lawyer. And he has successfully handled murders, assaults, robberies, cases of fraud. His main focus is the area of DWI, drug and sex offenses. And he has served on the board of the St. Louis County Bar Association. He's a member of MAABA, the Missouri Association of Criminal Defense Lawyers, as well as the National College for DWI Defense. And since
revocation of probation, but there are tons of collateral consequences that are never addressed, and most criminal defense attorneys do not address it. Employment, public housing, school loans, food assistance, child custody, schooling, adoption, voting, serving on a jury, serving a political role in office, firearm rights. So I like to talk about some of those collateral consequences before getting to Dobbs, but first thing to realize is as you sit here right now, you're subject to 3 different jurisdictions. You have the federal Eastern District of Missouri and their codes. You have St. Louis City and the state of Missouri. So you have the municipal code, the state code, and the federal code as you sit here right now. So you can think about the consequences that you're facing for criminal actions. And to understand our system, we have A, B, C, D, and E felonies. And then we have A, B, C, D misdemeanors, and then we have infractions, and those all carry different ranges of punishment. And the most important thing to understand about those ranges of punishment, you heard the term SIS stated several times in my introduction, suspended imposition of sentence. That's as good as it gets in criminal defense for a plea, meaning that you've admitted guilt, you've entered a plea, and the judge gives you a suspended imposition of sentence. Under Missouri law, under the Yale decision, a suspended imposition of sentence is not considered a conviction in the state of Missouri. But the problem becomes the federal government doesn't recognize that. The federal government only has one statute that actually states that they will take into consideration the state disposition and what it truly means for making determinations of loss of gun rights. All the other ones, housing, food benefits, etc., don't make a distinction between conviction. So they treat an SIS as a conviction. So that's another problem that we have, is that we are advising clients that, hey, in the state of Missouri, you're going to be good. This isn't a conviction. But we fail many times to tell them about the federal issues that they're going to face. And it's also not perfect. A suspended imposition of sentence is not a perfect resolution. A lot of lawyers misadvise their clients and tell them, oh, you're good. An SIS, records clean, everything's gonna be fine. But they don't realize that that's not true. When clients call me, I tell them, well, what are you asking when you say record? We have lots of records. You have an arrest record? Did your hand hit ink? Did it hit a computer screen? Now you're in the database for life unless you get a 610122 expungement. Do you have a driving record? Do you have a record with DFS, the central repository, central registry? So there's many different records that you have to consider. And the biggest thing we're facing is CaseNet. Corporations are downloading CaseNet every day to sell them to employers. So employers will know that even if you did get an SIS and you did get a 610 sunshine closed record, i.e. it comes off a CaseNet when you complete your SIS probation, they still have the records and they sell them to the employers. So these are things we all have to consider, and especially with employment, statistics show that 87% of employers are doing background checks. 60% of formerly incarcerated individuals remain unemployed 1 year after release. 40% of inmates lack a high school diploma or GED. So employment is tough. And if you think about it, and I was going through all the collateral consequences to present to you, there's professions where you would never think need certification. An embalmer, I mean, it's hard to get a job if you're going to have to do a background check and you have a conviction or you even have an SIS. Public housing, the denial of federal benefits. You know, we don't think about that. What if the client needs federal housing? What if the client needs that, but if they have a offense with prostitution or the possession of drugs or the use of drugs, they can lose federal housing. And that can mean everyone being evicted, not just that one person. And Missouri makes it clear that they're ineligible for protection from discrimination if they meet the criteria, i.e. a conviction for one of those offenses that I told you. So think about the word. I'm advising my client, I hear the word conviction. Well, an SIS is not a conviction in Missouri, but it is a conviction at federal level. So you have to be careful. You have to look at both sets. Private housing. I mean, come on. You know, if you own a property and someone wants you want to rent to someone, you're doing a background check or a credit check. School loans. People don't realize. I've had clients who I've been like, wait, you're in college? Wait, how are you paying for college? No, you can't take this deal because if you do 10 days in jail, they can terminate your grants. Food stamp, federal assistance. Thank gosh, Missouri was given discretion from the federal government to implement their own law. So Missouri went in and implemented their own law under 208-247. But federal law says that a felony conviction is grounds for ineligibility of food assistance. But Missouri went in and at least said, hey, it is, but we have a monitoring program. So we will monitor. We will make sure that you're getting drug tested. We will make sure you've done treatment. You can still get benefits. Child custody is another issue that we see with collateral consequences. You can't be placed in the home with a child that you have a finding of guilt against for certain crimes of violence, sexual crimes, and child support offenses. So think about that if you're advising a client and they're pleading guilty to a child support offense, and that's the child who did not get the support, but mom passes and dad needs to take care of the child. You have a problem. And one of the laws I've always hated, which my stepfather is about to challenge under 452375, is no court may award custody of an unsupervised visitation with a child to a parent who has been found guilty of a sex offense. So imagine that you have two parents and one parent passes away, but the other parent is a sex offender for a non-contact sex offense, and he's gone through rehabilitation, but now he can't get custody of his child. And the courts can terminate parental rights. Another thing you have to understand. A lot of lawyers don't understand the Safe Schools Act. So if a child is found guilty, is charged in juvenile court with one of 23 offenses under Missouri law, they have to advise the school within 5 days of that offense. And the school will then either remove them and put them in alternate education. Well, that can derail a child's entire path for the rest of his life. So that's something that we have to think about. I'm sure you understand voting. If currently incarcerated on misdemeanor or felony, you cannot vote. If currently on probation or parole for a felony conviction, you cannot vote. If it's ever an offense that has to do with voting, lifetime ban. And then the main thing that I see is firearms. You'd be amazed how obsessed individuals are with their guns. And that's one of the first questions I get. Well, I like to hunt. Can I possess a firearm? Well, a felony conviction makes possession of a firearm or ammunition illegal. And there's that word again, conviction. At least under the federal statute. And it's kind of funny that we don't have this with food stamps or the right to live, but with firearms, they've actually made a distinction where they leave it up to the state's law to determine whether or not it's a conviction or a non-conviction. So you can actually get an SIS on a felony in Missouri and still be able to possess a firearm. And that is something to understand, but also orders of protection, domestic violence offenses will make you ineligible. And then you have your concealed carry rights. I won't go through all those, but obviously if you take certain offenses, you won't be able to carry a firearm concealed. Ineligibility to be a state representative or a senator. If you lose the right to vote under those terms that I just said, then you are ineligible to be a state rep or a senator because you haven't been able to vote for the 3 years leading up to the election. And with all these rules and collateral consequences, Missouri has tried to fix a lot of this, which started with expungements under 610.122 for the arrest records, and has now led to expungements under 610.140, which are offense expungements. However, that is not a perfect solution. And it's kind of interesting because the hearsay has always been, the rumor has always been that the only reason we even got statute 610.140 is because a wealthy person got a lobbyist to convince someone in the state because he wanted his hunting rights back to get rid of his offense, which was passing a bad check felony. So he paid a lot of money to make sure that the law went into effect. And yes, it can help because we can expunge certain offenses, but it's not perfect. And the biggest change recently is Amendment 3, which I know you've been hearing about with marijuana. It's very impressive. As of January, they've already had 3,500 expungements granted. And even though they have until December to do felony expungements, 25 counties have already started. And I'm already getting CaseNet hits of certain marijuana offenses being expunged. So Missouri is trying to make changes to clean up a lot of these records so individuals can have certain rights restored, because I think they're learning that they are creating this cycle that they do not want. The other thing that I wanted to talk to you about today is kind of one of our newest laws is why you're here is abortion in Missouri and what has happened since the Dobbs decision. Now, when the Dobbs decision came down, I immediately started to get flooded with calls from local clinics that were providing abortion services and clinics in Illinois who wanted to provide abortion services to Missourians. So if you live in Missouri, it's horrible. We now have section 188.017 on the books, the Right to Life of the Unborn Child Act, and you will no longer be able to get abortion services in Missouri. But the biggest interesting legal issue that will be coming the next several years is Illinois. We are now 4 minutes from Illinois right now, and abortion is legal there. So it's going to be interesting to see how this is handled and how it goes forward. We don't have case law on it yet in Missouri because this is a brand new statute, but I'd like to go over the statute with you. 188.017 says no abortion shall be performed or induced upon a woman except in cases of medical emergency. Any person who knowingly performs or induces an abortion of an unborn child in violation of this subsection shall be guilty of a Class B felony. That's our second highest felony. That's up to 15 years in the Missouri Department of Corrections, as well as subject to suspension or revocation of his or her professional license. A woman upon whom an abortion is performed or induced in violation of the subsection shall not be prosecuted for a conspiracy to violate the provisions of this subsection. Not a huge fan of this language. prosecuted for a conspiracy, but can they still be prosecuted for the actual act of abortion under the statute? I get what the Missouri legislature is trying to do here. They're making the liability on the doctors, knowing that the doctors are not going to dare do an abortion if they do not want to lose their medical license or go to the Missouri Department of Corrections for 15 years. But this language leaves that question open. It shall be an affirmative defense for any person alleged to have violated the provisions of subsection 2 of this section that the person performed or induced an abortion because of a medical emergency. So they shift the burden to the doctor to show that it was for a medical emergency. And the definition of abortion under 188.015 is the act of using or prescribing any instrument, device, medicine, drug, or any other means or substance with the intent to destroy the life of an embryo or fetus in his or her mother's womb. And that's where the big war is going to be coming, medicine. As a lot of people don't understand, most abortions are induced by 2 different medications. I call them MIS and MIF, and they are used for abortion purposes. The issue with those 2 drugs is the first one is usually administered at the clinic, and the second one is administered 2 days later and typically sent home with the patient. And I'm sure lawyers can think of sent home with the patient. So they're sending drugs from Illinois into Missouri that could potentially, under definition of the statute, cause the abortion. And now the doctor in Illinois has just created a jurisdictional nexus to be prosecuted in the state of Missouri for an abortion. So you can tell why they're all calling me to go over all of this. Missouri also has laws that can be used to stretch 188.017. We have a very state-friendly aiding and abetting law, which is called section 562.041, which is responsibility for the conduct of another. A person is criminally responsible for the conduct of another when either before or during the commission of an offense with the purpose of promoting the commission of an offense, he or she aids or agrees to aid or attempts to aid such other person in planning, committing, or attempting to commit the offense. So think about that language in terms with the abortion statute, and think about all those hypotheticals that you can think about that I'm going to go over in a second. We also have an attempt statute, attempting to commit a substantial step. We also have conspiracy statute, which was actually the words mentioned in the abortion statute, which is a person commits the offense of conspiracy to commit in any manner or for any purpose an offense if the person agrees with one or more persons to commit. Hey, honey, I'm going to drive you to Illinois for your abortion. We'll get that drug and we'll bring it back to Missouri. You can take it 2 days later. So it's a lot of things to think about. It's clear as day. If a doctor in Missouri performs an abortion, they're looking at a Class B felony. They're looking at loss of professional license. But where's the other clarity? Let's think about farther down. What happens if a Missouri doctor tells a patient, hey, I can't perform this abortion here, but I know this clinic in Illinois, they can perform the abortion. I'm going to give you all the information. I'm going to help schedule your appointment. Think about that. Where does that fall under responsibility of conduct of another and conspiracy? How about the Illinois doctor who says, okay, I've listened to Mr. Fry. We're going to keep them in Illinois to use medication 1 and medication 2. We'll put them up in housing. We're going to take donations to pay for it. And then we're going to send them back to Missouri. And then somebody figures out that actually the fetus did not abort until the woman was back in Missouri because she responded differently to the medication. We did everything we could to protect criminal liability, but do they have a case under the language of the statute? They sure do. And then the hypothetical that's the scariest, which is, well, we think it's safer for the mother to take this second medication 48 hours later, but we're going to rush it because we got to do them both at the same time. Now, medical research says we can do it. It's not the best, but we're going to do it now. Well, now we're impacting the mother's health. But if we do send her home with the medication, now we potentially committed a crime. So think about the issues that this is causing. And then what happens if I have a friend who needs an abortion and she has no money and I give her $5,000 to go to Illinois and get an abortion, and someone turns me over to the authorities. Was I aiding and abetting an abortion? So, you know, these are things to think about. But like I tell everyone, when they ask me a criminal question, I say criminal questions have two answers. You have a legal answer and you have a practical answer. So I just gave you the legal answers. The practical answers are this. It's still a tough crime to investigate. You would have to have someone with very intimate knowledge, because we still have HIPAA rights. Yes, I understand that HIPAA gives away to certain court orders. Law enforcement, though, has to get investigative subpoenas. Law enforcement has to get court orders to get many of these medical records. So it still is not the easiest offense to investigate. There are more legislation that is possibly coming down the pipe also. One of the first bills was in December of 21 by Representative Mary Coleman, House Bill 1987, where she wants to adopt the Texas policy, which is we can sue someone civilly if we find out they helped give an abortion. So it allows a right of friend to sue. So basically someone can come forward and say, hey, I know this doctor gave an abortion to Susanna and I want to sue that doctor. This is her way of trying to shut down the abortions happening in Illinois, because she believes there's still a nexus for the civil lawsuit. That did not go anywhere. They reintroduced it in 2022, and they've actually reintroduced it this year again. It still has not gone anywhere. Representative Brian Seitz pre-filed House Bill 163, where he wants to ban the importation, exportation of abortion-inducing drugs and make it a Class B felony. That's trying to combat the drugs, as I told you. I spoke to our lobbyist in the Missouri House, and he says he does not see any major abortion changes happening this session. So that's good to hear in regards to it getting even stricter. And then the last question, which comes down to legal versus practical, is will Missouri enforce the abortion laws? On June 24th, 2022, 83 elected prosecutors from around the nation committed to not enforcing the abortion laws. One of those was Mr. Bell in St. Louis County. We know what Eric Schmidt's position was. He made it clear 4 minutes after this decision came down. We now know what the new AG's position is, as he joined on February 13th a national move to block the FDA's rule allowing the abortion pills to be delivered in the mail. And now we have to ask ourselves, when will the AG get involved? Recently in the news, I'm sure you've seen that an AG will get involved in local matters. And we have to ask ourselves, will he get involved in this? So what happens if a doctor in St. Louis County performs an abortion and Wes Bell says, I'm not going to prosecute this doctor? We know that's going to be the biggest story in the entire nation. And we know that the AG is going to file to intervene. And section 56.110 says that the AG can be appointed as a special prosecutor by a court when local prosecutors have a conflict of interest. I would say a conflict of interest is a prosecutor coming out and saying, I'm not going to follow the laws of my state. So it's going to happen. And now you have to ask yourself, what's even scarier, we have all these counties in Missouri that are all different colors. Some are red and some are blue. And some of the blues aren't going to prosecute, but those red ones, I think, sure would love to prosecute a case like this. So doctors even have to think about that. So, you know, what it comes down to is it's very scary that a doctor, I guess I became very scared when I started to talk to the doctors and I saw how scared they are. I could not imagine sitting down with someone and being prepared to give them legal advice that could save their life metaphorically in our industry. And I have to stop and think, can I really give this advice? Should I give this advice? And the doctors are scared because they've worked as hard as we have to get our licensing and they don't want to lose it, but they also want to help. So it will be an interesting battleground for the next decade to see what happens. Please, if someone reaches out to you for help in this arena, please help them. The doctors just want to do the right thing and not have to make that decision where am I going to be saving this woman's life or am I going to be going to prison? So I appreciate you listening to me in regards to the collateral consequences. Hopefully I've explained them so that you understand a lot of the things that we look out for in criminal law and hopefully given a little insight into Dobbs and what we are facing currently. So.
Thank you much. Okay, my name is Germán González. Thank you, Rick, for presenting me today. I am the founder and president of González Herrera Law Firm. I have been practicing law for around 6 years, and I opened my own practice 4 years ago. I'm also the immediate past president of the Hispanic Bar Association here in San Luis. Before starting, I want to ask a question. Have you ever wondered what happens when an immigrant is found guilty of a felony or misdemeanor? If you have never had an immigrant client, maybe you have never asked or addressed that question. But this question needs to be addressed by us, attorney, by us, a community, and also by the U.S. Congress and Missouri Congress and all the state Congress, because United States is not just for U.S. citizens, or it's not the people that is living in the United States are not U.S. citizens. They are different kind of immigrants with different kind of status, and also we need to, for that reason, we need to have these questions to be addressed all the time. Now, I want to talk about 4 different topics today about the immigration consequences of an unlawful abortion here in Missouri. First, I want to start to what is considered a conviction for immigration purposes. Then I want to move to, can an unlawful abortion be considered a crime involving moral turpitude? And can a person who commits unlawful abortion be considered to lack good moral character for immigration purposes? And then practical obstacles for non-citizens to get an abortion. Oh, thank you. So the definition of conviction for immigration purposes is in the Immigrant Nationality Act 101A48A. So they are like a formal judgment that is a normal judgment that everyone knows. And if the adjudication of guilt has been withheld, can be considered a conviction for immigration purposes when the judge or jury finds the non-citizen guilty, or non-citizen enters a guilty plea, or non-citizen enters a plea of nolo contendere, or non-citizen admits sufficient facts to warrant a finding of guilt. Plus, a judge orders some form of punishment, penalty, or restraint on liberty. This is very similar what Matt taught recently about the different adjudication or judicial diversion or any kind of program that the criminal justice has. So just to what the attorneys need to have in mind when the client is a non-citizen or is an immigrant is first to make sure that in the record, in the document, there is not any kind of found of guilty, not by the judge, not by the jury, of course, not by the non-citizen pleading guilty. Or, and this is very important, that the non-citizens admit the sufficient facts to warrant a finding of guilt. It is the non-citizen, cannot be the judge. If the judge admits sufficient facts on the documents, it's fine. The most important is that the non-citizen is not admitting those facts. And regarding the punishment, it is very interesting because fine, of course, is a punishment, probation is a punishment, imprisonment is a punishment, or any kind of thing that you can think that is a punishment, plus court cost. So after 2008, the BIA, that is the Board of Immigration's Appeals, in the matter of Carrera, decided that court cost is still a punishment. So it's very important when you are doing or working with an immigrant, just to make sure that you are addressing all these elements for planning to not have any issue in the future. So what to be aware? First is all these elements, and second, attorney and non-citizen need to be aware of what crime the person is pleading guilty of, because depending on what is pleading guilty are the consequences. Sometimes there is no consequences, sometimes of course there are. I want to give an example of a person that was maybe 3 years ago. A person was charged with endangering the life of a child in third degree. But in fact, the child never was in danger. But that was the criminal attorney said, I think that is maybe not an issue here because there was in fact not, the child was not in danger. There would not be any kind of punishment, like a big punishment in prison or something like that. I said, if she pled guilty for endangering the life of a child, first, it's a mandatory detention for immigration purposes, and second, that person will lose maybe all the relief that she has for immigration deportation. So back and forward, I wrote a letter for the prosecutor and then take out or drop the charges for this immigrant. That was amazing. So now, can unlawful abortion be considered a crime involving moral turpitude? I think that the short answer is, I don't think so at this time. What is a crime involving moral turpitude, CIMT? Matter of Silva Trevino, and in 2008, that is in the BIA again, they said that a crime that involves reprehensible conduct and some culpable mental states, like a specific intent, deliberateness, willfulness. So, like you can see, the definition is very vague. Reprehensible conduct, they have tried to explain that it's something that is evil or morally wrong act. So in the practice, what is happening is that the BIA, they has like a lot of sets of crimes that can be involved moral turpitude. In 1946, the BIA stated that abortion is a CIMT, but that was many years ago. I don't think that I think that our community and the immigration system has evolved enough to understand that an abortion is not or cannot be considered a CIMT, but still the door is open. Can be considered in the future? Maybe yes. Okay. One of the crimes that can be a CIMT is a crime against a person. So if the fetus in the future can be considered a person or not, or how they can connect that one to explain or to argue that the CIMT that the unlawful abortion is a CIMT, maybe. But at this time, I don't think so that it is. Okay, if a person is found guilty for a crime that is a CIMT that affects deportability or removability of the person, cancellation or removal, the person cannot apply for cancellation or removal. Adjustment of the status and naturalization can be affected for being convicted for a crime involving moral turpitude. Now, can a person who commits unlawful abortion be considered to lack good moral character for immigration purposes? The answer is yes. The Immigration Nationality Act 101 F define one of the lack of one of the definition of lacking good moral character is be convicted for a crime that results in a prison sentence of more than 180 days. The unlawful abortion has a prison sentence between 5 and 15 years. So there is more than 180 days. So that can affect a person if he is found guilty of a unlawful abortion. So let me explain here why I think that it is a big issue. As Matt was explaining, the doctors are afraid, of course, to practice an abortion in Missouri. He said, what happened if a doctor in Illinois practice an abortion and the person comes here to the United States, they compel or friends assist the person with money or traveling to Illinois. And what happens if this friend does not have any status in the United States or have a visa, like tourist visa or employment authorization or unemployment visa? So that person can be affected for aiding and abetting. He is found guilty of unlawful abortion or helping with an unlawful abortion. How? So if the person is a legal permanent resident, and he does not have a good moral character, depends on the time frame that he commit the crime, he cannot get a naturalization. It's not it's just a temporary bar. It's not permanent, but it still is a bar that the person will have. If the person is a non-citizen and abetted and aided, that person can be put in immigration proceedings. If it's not, and maybe his only option could be cancellation or removal. But one of the elements to prove that the person, or to prove cancellation or removal, is that the person does not lack good moral character for the last 10 years. So if the person helps someone, is one of the elements of the cancellation or removal is done. This person will be deported. Another problem that I see is many doctors in the United States are here with an employment visa. So if in Illinois, the person helps someone and the person comes to the United States and he is convicted, he also can be facing a deportation in the future, possible, okay? So I think that this thing or this good moral character topic is very important for to analyze in order to advise a person of pleading guilty of an unlawful abortion, okay? Practical obstacles for non-citizens get an abortion. I think that the first one for non-citizens, fear is the most biggest obstacle. They are feared to have any contact with the police or with the prosecutors, even to go to court for a minor traffic violation. They are scared to go. They hire attorneys to help them because they are scared to have any contact with the judicial system. So I understand that the law does not, or is not looking to prosecute the pregnant person. But still, the prosecutors can go to the pregnant person that got an abortion, or to ask questions, to make a case against the doctor, and just for being in contact with the prosecutor or with the police, they can just ask more questions and call ICE, and can come and take her into custody. That happened on Trump administration. Something that happened very often was that the people that was stopped just for not having a valid driver license, they just called ICE. And many people are now in immigration proceedings because of that. So it's not just the fear to go and be caught to getting or to abort, but it's also what happened if this is triggering prosecutors, police, or someone else to come to me to ask more questions. For the friends that does not have a legal status will be the same, because as I already explained, they can be facing for aiding and abetting to getting an unlawful abortion in Missouri. So I think that all these obstacles can be a big issue for our community. To connect a little bit with what Matt said, in addition to getting or to explain maybe different with different law, people that Matt said people love our guns, and I have a case in the past that he was a non-citizen. He came when he was 2 or 3 years old to the United States, and all his friends had guns, and all his friends were US. So what happened was that he did not have gun, but the friend said, "Hey, take my gun for today," and blah blah blah. It was for just shooting one time or whatever. And they took a picture and they posted on Facebook like, because we are a badass, something like that. Yeah. And this photo ended up in the hands of an ICE officer. ICE officer made a lot of investigation, took him into custody, and that is a mandatory detention to have guns. Having been in mandatory detention complicates the situation for the immigrant, because it's like 6 months around for all the proceedings. In 6 months, it's very hard to get all the evidence to protect someone. And this person, we tried the best to get him out on bond. We did everything that we could. We explained the mother that was a mandatory detention. We explained everything. The only good thing on everything of this was after he was deported, like 1 year later, the family contacted me and they said that he's happy. Now he's making a life out of the United States. So that is something good there. But still, he's separated from all his family, for mother, for father, for sister and brothers. So all these kind of consequences are very important to be addressed, as Matt said. It's very important to see point by point, to see what is going on, to try to help the person. Good to know that Missouri is trying to help people, at least for the marijuana thing, for the expungement. Bad thing about the marijuana is that marijuana is still a federal crime, meaning if an immigrant smokes marijuana, even though in Missouri that is legal, or in Illinois or in Colorado, whatever, it's still a federal felony, and the person can be convicted and can have immigration consequences as well. The other thing I wanted to talk was, it is a little bit about the abortion, is the intentional termination of a pregnancy. It's one of the definitions of abortion here in Missouri. And I think that can be an issue in the future. We will see. I hope that will not be any issue for the mothers when they take appeals by their own, or if they move to another state to get in an abortion. But that is everything that I have for you. If you have any questions.
Thank you so much.
All right, guys, so thank you very much. Are there any questions from those present in the room? Seeing no hands. The record reflect that there are no questions. What about online? There is a question online.
Are you able to access it on the screen?
Go to that 25 tab. Up there when the chat 25.
Yeah.
It's at the very bottom, Samra Cordage.
These laws prohibiting abortion applied to companies that reimburse employees for abortion care, can they be liable for aiding and abetting? I'm not even gonna try that.
We have no law specifically on the books for that, but as I was discussing in the collateral consequences portion, as I said, the aiding and abetting law in Missouri is very liberal. The conspiracy language is very liberal. The case law is very liberal for extending both of those. And that could be something that comes forward. I would not be surprised if you don't see a law being passed in the Missouri legislature dealing with something like that. So again, can't give you an exact answer because we have no cases on the books currently, but from the language that I cited earlier, it could be a potential issue.
In fact, the question's probably giving some other people ideas. Are there any other questions from the online audience or the audience here? Okay. Then thank you guys for the presentations. Alex will, I guess, wrap us up.
Quick second, just to mention two members of the board, of our boards of the organizing associations, Fatima Khan, her dad is very ill, so that member of the South Asian Bar Association, and Frank Carachero, a member of the board of the Hispanic Bar Association, just lost his dad. So keeping both of them in mind. Hate crimes were mentioned by Bonyen and they've come up. It's, I think, worth noting that our associations have, during the organization period in the last couple of months of this particular event, had to respond to hate crimes that are occurring in the community. In fact, Celestine Dotson has had to step away. We are often called on to speak to the press and address issues in the community. Also, as a member of the Hispanic Leaders Group, getting involved in these things. So these are happening, boots on the ground. It's happening on an almost daily basis. Unfortunately, I want to conclude with saying that there is international interest in this. We have actually my understanding is 3 doctors from France watching this presentation right now. And we do also actually have press from the Spanish media here from Kansas City, from that side of the state, who drove all the way in just for this event. So there has been a lot of interest. Thank you for your presence. Thank you online. I know I said earlier that I don't like, I love Zoom presentations. It's just hard when I'm responsible for the tech. So thank you for all the help. This could not have been possible without the wonderful assistance from all 4 bar associations. And that will lead me to the final note for our CLE today and from MAABA. Thank you so much.
Thank you for giving me the spotlight. I didn't do anything, just show up. Thank you all, thank you for coming, and thank you for the speakers for coming. This is a wonderful presentation. I think we all agree. And so I don't have much else to say. There's a lunch provided, sponsored by MAABA, Young Lawyers Division. Thank you all for coming.